we have one more very esteemed speaker who we want to give plenty of time to share those insights into when laws are not being implemented, what can we do about them? So how do we ensure that laws get enforced in the first place? It's not good enough to have them just on paper. But what can we as citizens do about ensuring that the member states that are responsible for implementing the laws actually do so? And our speaker is Stephen Allen, who's the director of Validity Foundation, which is an organization which is based in Budapest in Hungary, but works across Europe and wider afield even, and specializes in in what's called strategic litigation, which means taking cases to courts to make sure that the rights are defended and implemented. But of course, I'm going to let Stephen talk more and explain that in more detail. Thank you.
Well, John, thank you so much for the invitation. And let me start with an apology to you all. I did not want to be the reason for you to miss a break or skip a break, but let's make this dynamic. Feel free, of course, to ensure your needs are taken care of. And please, can I say, do feel free to jump in at any point in this discussion, because this is really, I hope, going to build on the first two sessions, but it's going to be very much about practically using EU law from some of our experience. So I'm going to share my screen. I just need to know if you can see it before I skip ahead. Could someone just let me know if you can see that?
Yes, we're seeing it. You need to go into presentation mode.
Presentation.
Wonderful. So hopefully it's in presentation mode. Am I right?
Yeah. Good.
Lovely. So I have to say it's been great to listen to both Gabrielle and Alejandro. They both bring extensive knowledge and experience about what EU law and policy formation looked like. And they bring that very much from the perspective of all European citizens trying to act at the European level. So I think it's been very technical. It's been very interesting to listen to. I think what I'm going to try and take us to now is a little bit more about what happens and how we can influence the way in which EU law and policy is put into action. So I'm here talking about not just kind of what result we get from the negotiations or the legislative procedure, but what happens when we've now got these laws? How do we monitor them? How do we ensure that they're enforced? And what happens when member states or the EU itself, let's say, doesn't actually implement those laws? Okay. So John's already kindly said a few words about the Validity Foundation, but I'll start just to say that yes, we're based in Budapest. Let me say Budapest is a very different place now than it was 2 or 3 weeks ago, or it feels quite different. But we've been based here for over 20 years. And we are a specialized organization who works on strategic litigation to promote the rights of people with disabilities. That's particularly our focus is persons with intellectual disabilities and persons with psychosocial disabilities. But of course, we work with people who have all sorts of impairments and needs, and we do that across Europe, but we're also very active in Africa as well. And we actually provide legal inputs internationally all over the world into cases that are designed really to push for the implementation of the human rights of people with disabilities. And we do that very strongly and explicitly connected to the Convention on the Rights of Persons with Disabilities as the primary and most important source of law, which, I mean, we've been talking a little bit about already today. Some of the big topics we work on, and we've taken some really important cases, including in Europe, on these relate to the rights to equality before the law or the right to legal capacity, as well as the right to independent living and inclusion in the community. And I will touch on some of the cases and areas of work we've done on this. But today, for example, it's maybe useful to know that Validity has the largest docket of cases in the world on disability rights litigation before the European Court of Human Rights. We've also taken cases before the Court of Justice of the European Union, and we now have litigation at the African continental level, including at the African Commission on Human Rights and the African Court. So we really take that international perspective on the implementation of CRPD norms. This session, and you've heard already a huge amount of input today, but I've got sort of three parts I want to touch on. The first is, after we've had that legislative process that you've heard a lot about coming from Brussels, what happens next? How does that EU law get transposed into national laws? And how do we begin our monitoring process? How do we see whether member states are living up to both the letter and the spirit of EU law and also the CRPD? Second thing I want to touch on is going to be to discuss what happens when things go wrong. And here I will talk about infringement proceedings. This is a power that is controlled by the European Commission in the case that a member state does not or imperfectly implements EU law. And we're going to look at this step by step. And because in the third part of this, we will look at really what is the role that we as civil society can play, not just in the Brussels, in Brussels around the development of the laws, but what can we play across all member states? What can grassroots organisations get involved with, and why is that important to the implementation of EU law in the field of disability rights? So here's where we start. And in the field of disability rights, we can start by acknowledging that the EU, as you've heard, has already some very strong laws designed to promote equality, inclusion, and also to tackle the forms of discrimination that people with disabilities commonly face across Europe. One of the most important areas or laws is called the Charter of Fundamental Rights. And this is about as close to human rights as we get in the European Union. It is a very strong commitment to the principles of inclusion, quality of life, access to employment, and it really covers the fundamental principles that should guide all European action. That means the action of both the European institutions, but also the member states. And so it's quite a strong source of law. We've also got, as you've heard, more specific areas of law relevant to the lives of persons with disabilities. That includes things such as the European Accessibility Act that you've heard about. But as we've also discussed, it covers a broad range of areas of EU policy, some of which directly affect persons with disabilities, and some of which affect people with disabilities as a segment of the wider population. So there are some really strong areas of law that we can draw on. Now, the thing that is really important to understand about EU laws, whether these be regulations or directives, is that EU law itself is not self-executing, all right? So it doesn't have any immediate impact until there are some further steps taken. And this is the process that's been referred to earlier as transposition. of EU laws. And transposition is that process of giving force to EU laws in EU member states. That has to happen in a certain time period, as you've heard, in respect of directives. And it's a critical and often very complex process, which is monitored by the European Commission. Now, I raise this now because this transposition process is an area where civil society organizations and people with disabilities can and should be involved in monitoring and advocacy. And beyond the legal changes that the capitals all have to make, the real change comes when governments begin to commit policy measures to implementing these laws, where they start to identify and allocate resources, and they start to take actions that have an impact on the ground in people's lives. Whether that is about the development of new types of services or the improvement of public health services, for example, or whether that's about changing education systems so that they are more inclusive for children with disabilities. The real change that can be important here is when we see that change on the ground through the commitment of resourcing. But it's important for me to say, and this is a big area of work that we work in, is that challenges often arise in this process of transposition. It is not uncommon for member states to take no steps to implement EU law at all. It's also not uncommon that member states take incorrect measures to implement EU laws, or they take an insufficient approach to achieving the goals of a particular piece of EU law. And another set of problems very much relates to weak implementation. The law might stay on paper, it might look very, very good on paper, but this happens often where no real policy commitment is made by member states, or where budgets are not genuinely moved to support the objectives of the legislation. So we in civil society, and I think we in the disability rights movement, need to think carefully. How do we identify problems in the process or identify what is happening during this transposition process? How do we monitor these processes in a meaningful way? But most critically, how do we ensure that these measures promote disability rights and they don't violate disability rights? And I'm going to share some examples later in this presentation based on our work. So you've had a lot of input today, and I'm not going to do death by PowerPoint, but what I want you to know is that the European Commission has the primary role, at least at the European level, of monitoring the transposition and implementation of EU law on a day-to-day basis. And it's got really strong powers to do that. It can monitor the actions that each of the member states take on an ongoing basis. It can act and warn governments when it sees that member states are failing to implement EU law, and it can do that through something called infringement proceedings. But it also has huge other areas of technical and financial power, such as providing funding through its various funding mechanisms to EU member states to ensure that EU policy and law is implemented, and as well as implementing sanctions on those member states that fail to correctly spend the money or spend it in violation of EU law. So it has a lot of power, the European Commission. It is like the day-to-day government of the EU. Now, the second kind of part of this picture are member states. And member states, the 27 countries of the EU, actually have the primary obligation to implement EU law, and they have to do that in all sorts of ways. Their governments and parliaments must adopt laws that implement EU law in their national systems. It's not enough often just to have an EU law stay in Brussels or in the European institutions. It then needs implementing within domestic legal systems through either adopting new laws, amending laws, etc. Member states also have to have monitoring bodies at the national level that are independent and can check implementation of EU law in their countries. And often this mandate falls to national human rights institutions and parliamentary ombudsmen. And of course, the courts in each of the member states have primary power to implement EU laws within cases taking place in that country. You've heard, and I will mention later, about the Court of Justice of the EU, which is which is an EU institution and is the supreme judicial authority of the EU. But it's important to understand that very few cases on EU law ever get to that court. In fact, on a day-to-day basis, EU law is judged and adjudicated in national courts, and those courts have an obligation to comply with EU law. So those are the two big players, the European Commission on the one hand, the member states on the next. But there's a third, and I would argue that we in civil society are one of the critical pillars to ensure the implementation of EU law on a day-to-day basis genuinely makes real change for the constituencies we represent. Now, EU law is also clear that civil society, it's not just a good thing to consult civil society, but civil society must be consulted on many areas of EU law and policy implementation. And often governments must set up formal consultation mechanisms to do so throughout law and policy making processes, as well as in terms of independent monitoring and scrutiny. So we don't just have an important role, we also have the support of EU law itself to argue for a place at the table when it comes to EU law and policy. One of the things we in NGOs and civil society are often better than the Commission to do is to monitor the real world impact on the lives of our people of EU law and policy. And in fact, because we have our knowledge and expertise in the areas we work in, we're often much closer to the real impacts of how law and policy impacts on persons with disabilities. And I'm absolutely sure that is the case for the network here for Cerebral Palsy Europe, for example. And the other thing that we're good at doing, and I think the disability rights community generally is good at doing, is identifying specific issues, barriers, and violations that we face and which EU law should be addressing and which member states should be dealing with. So we're good at identifying these, and we have a critical role in collecting this information. And then we also have a really important role in promoting and enhancing accountability. So this is the more hard type of advocacy we sometimes do. But where we see problems, we are best positioned often to collect evidence of those and to submit complaints or information to the relevant authorities. And that's a critical role because often national monitoring bodies and the European Commission simply don't get this information on a day-to-day basis unless we in civil society are on the ground, are collecting it and actually raising it within those forums. So in this kind of tripartite, if you can call it, I would argue that effective enforcement of EU law depends on all of us working together in different ways. And we don't need to be too shy in civil society in demanding our seat at the table. In fact, as I've said before, often we hold credibility because we are most connected to the people who need to benefit from EU law and policy. And that means we've got information and expertise that both member states and the European institutions need. So this is the kind of theoretical setup. But what happens when this system doesn't work? So let's talk about this kind of shift, if you like, from law to real lives. And we're going to go through this in more detail as I go through this presentation. But in essence, as I've said, the adoption of an EU law really is just the kind of first stage in a much longer process of change which ultimately should have a positive impact on the lives of people with disabilities. The second stage I've mentioned is about national laws need to be changed and policies need to be developed in this process of transposition of EU law. It means making plans and allocating resources. The third step, as I've spoken about here, is about creating services and actual real systems on the ground to implement these EU laws and policies. And that could be in all sorts of areas, whether we're talking about enhancing accessibility of the built environment, or we're talking about ensuring that people have access to support services in their homes. These require investment and planning to ensure that we have the right people, we have the workforce, we have the funding structures, and we have all of those elements in place for a system to begin to work. And of course, finally, the fourth part here is that there should be a real and measurable impact on the lives of people with disabilities. And we in the disability movement should be the ones who I think are consulted about what does it mean to monitor impact. Taking the CRPD as our inspiration of our movement, I think the things that we need to be looking for are whether EU law and policy genuinely promote independence. Are they supporting real inclusion and social participation? And are we seeing greater opportunities, respect, and dignity for people in their communities? Now, you can't possibly see that from here in the capital Budapest or in Brussels alone. That really means that the impact is about grassroots level. It's right out across our communities, across our societies. It's not about just what happens in capitals. All right. And as EU law doesn't implement itself, every single step is a process, I think, where we in the disability community need to be engaged, monitoring and ensuring accountability for the final beneficiaries, that is, people with disabilities, in this from this perspective. All right. So, what does implementation involve? We've spoken about transposition, we've spoken about policy and systems, and we've spoken about the translation of this into practice. But as we move into the next stage, I want us to be thinking now critically and carefully, because there's often an assumption that this process will go smoothly and things will be improved. And we hope this to be the case in respect of disability rights in Europe. But it's also true to say that disability rights can also be violated through this process. And we need to ensure that we are really thinking critically throughout the whole process. So why is implementation now in EU law so critical for disability rights? Well, otherwise, if we don't focus on this implementation process, really we can have the most beautifully written laws, but it's going to remain on paper and it's not going to affect people's lives. From our perspective, in the work that Validity has worked on for the last 2 decades, it's still the case that the right to independent living and inclusion in the community remains a huge challenge. And it's still the case that people with disabilities are often denied access to their equal recognition before the law. That means in many countries, they still can't play a full part in the public life of their communities and societies. It means that many people still remain under guardianship and can't, for example, even vote. So we know that these rights are critical, and we also know that we need to be keeping a careful eye on them in the process of the implementation of EU law. And when implementation of EU law fails or goes wrong, unfortunately, we need to be aware that these changes and these big shifts we're talking about can actually, by mistake, sometimes perpetuate segregation of people with disabilities. Sometimes, when member states take the wrong measures to implement EU law, an area that we've worked a lot on in the field of independent living, we can see huge amounts of public investment going into the wrong models of support for people with disabilities. And that's a huge problem, I think, right across the disability movement in Europe and beyond. And we can also see, if this process is not carefully monitored and controlled, that exclusion can increase rather than decrease. And so when implementation goes wrong, barriers remain erected, preventing people from being more a part of their communities. Exclusion continues, and we see that people with disabilities are not genuinely involved, either in their societies or in policy and lawmaking processes. So implementation really is the bridge between disability rights and reality, which we hope to be better for citizens with disabilities in Europe. How do we make sure that this bridge works in reality? Well, I've already mentioned some of these elements, so I'm going to move through this relatively quickly, but you need to understand that the Commission, as I've mentioned, has a role after laws are adopted to monitor this transposition process in real time. It must engage in ongoing dialogue with member states and provide technical assistance to countries to implement new laws and policies. But as I've also said, it can launch infringement proceedings when needed, and this is where countries fail to transpose laws correctly. Member states have that obligation to transpose EU directives into national law, and they must design policies and allocate resources to deliver the services required. And they are ultimately responsible for ensuring real change on the ground. Whereas we in civil society have this role of tracking implementation, holding governments accountable, and I think critically amplifying the voices of people with disabilities within this process. Because there's no point in just having loads of experts around the table if ultimately the final beneficiaries themselves are not seeing a real impact. None of these actors alone can ensure effective implementation, and so it really does depend on full collaboration, accountability, and active participation. Now, I'll move to the next part of what I wanted to present, and this is the EU infringement procedure. Okay. And this is, as we were talking about earlier, about what happens when this transposition process really either isn't going well or member state is just not proceeding at all with it. This is an 8-step process, and we're going to go through each of these processes one at a time. But the EU infringement procedure was designed in such a way as to ensure not only that the EU is a community of countries working together, but actually that EU member states are fulfilling their obligations of membership to the EU, and that is through proper implementation of EU law. It's great to be a member of the EU club, but when you are, you have obligations, and that is to follow the European treaties as well as European laws. And when it doesn't happen well, we can see that the EU has an effective process here to hold member states to account. That starts with a complaint or information that indicates violation of EU law, and can move all the way through the various stages that I'm going to talk about shortly, through to a judicial finding against the member state and even the imposition of financial or other penalties on EU member states that really fail to implement EU law. And throughout this process, what I want to place a particular emphasis on is our role in civil society throughout this process, because often we are the key triggers of making it, of getting action from the European Commission, for example. And often we have the information that is necessary in the process that proceeds between the Commission and the member state. So firstly, as I've mentioned, the infringement process begins when there is a complaint, when there is information indicating that EU law is not being implemented by an EU member state. And you need to know that this information could be all sorts of sources, but when the Commission gets this type of information, it can act on the complaint. And it can be from any source, really, within the European Union. It can be from individual citizens, it can be from businesses, it can be from NGOs, it could be from organizations of people with disabilities, or it can be on its own initiative, and it is supposed to also monitor carefully for itself. But we often in civil society are the ones who bring information to light, especially in the field of disability rights. And we have a critical role in triggering this process, which is about ensuring that rights are protected for citizens with disabilities. Now, when the Commission gets this information, we can move into a process where the Commission starts to raise concerns with the country in question. And it does that through what is called a letter of formal notice, where the Commission writes down, in essence, its observations based on the information it's collected as to how the EU member state may be violating EU law. All right. So this is the kind of first formal notice, if you like, from the EU to a capital that, hey, we've got a problem here and we want you to reply. Now, often that letter of formal notice is obviously quite legalistic, but it's usually based on extensive information, information that may have been provided by NGOs and organizations of people with disabilities. And so we could already see here the critical role that we can play, both in being aware of EU laws and policies relevant to people with disabilities, but raising our voices also when there is a concern. Now, after the concern is raised, the member state usually has about 2 months to reply to the European Commission with its own observations. It'll say, well, yes, we accept that there are some problems, but we're going to do this, this, and this to fix the problems. And that might be, for example, amending laws or amending policies, etc. So this would be a collaborative response from the member state. The member state might also, however, reject the allegations in the formal letter and say, well, actually, no, we disagree and we have complied with EU law. We've done this, this, and this. And often these replies can go on for tens of pages, hundreds of pages, where it comes to legal measures that they may have taken. Okay. And so this is really where the member state defends itself. And sometimes it will be more collaborative with the European Commission and say, yes, we realize that our law on accessibility of the built environment is not strong enough. And actually, the problem we have is that we don't have enough technical expertise in our country. So can you help us? And that might be seen as quite a collaborative reply. Okay. But very commonly, of course, member states don't like being told that they're violating the law, and often they will defend themselves and reject the claims of the Commission. Now, at this stage, the Commission will have the information it collected originally, and it'll have the reply from the member state. But then it will also be looking for all sorts of other information to see really whether there is a problem where it needs to use its enforcement powers throughout this procedure. It should be actively and proactively collecting information and submissions from NGOs and civil society. It should be looking at all of the available data and documents, including those databases that you heard about earlier, about the impact or implementation of EU law in real life, where that information exists, and it should be collecting that. It should be also collecting direct input from communities that are affected, including through consultations where necessary. And it needs to really look at all of this information to see whether, in its view, in the Commission's view, the member state has taken genuine action to implement EU law, and that the action that is taken has been in alignment with both the letter and the spirit of the EU law in question and the EU treaties. Now, I'll stop just for a second here because there is something else that's very critical that should be considered at this stage by the Commission, and that's the EU's own obligations under international law. And one of them you've already heard about is the Convention on the Rights of Persons with Disabilities, which is not a piece of EU law. In fact, it's a piece of international law that binds both the EU and all of its member states, and really should be considered across all areas of law, whether disability specific or not. So at this stage, it's quite critical that the Commission considers that. I will say, and it might not become as a surprise to some of you, that we find that the Commission sometimes is not very good at this analysis, and particularly under the CRPD. And so I think civil society, we in the disability rights community, have a really important role in informing that analysis. Let's move to the next stage, which is in the case that the Commission then comes to the view that that EU law has either been violated or not transposed correctly, it will then send a second formal letter, and this one is called a reasoned opinion to the member state. And this is like really a more formal statement of claim of the violation of EU law to the member state concerned. And it will consider all of the evidence that has been given to it, and it will make a judgment as to whether or not the current situation is that the member state is in violation of EU law. And if it does make that claim, it will begin indicating that the member state needs now to take urgent measures to change the situation, to come back into compliance with the European Union law. And this is a very formal process. But the member state, again, is usually given 2 months to comply with this reasoned opinion. And the reasoned opinion itself is a highly legal assessment. Essentially, this is where the European Commission is laying out its full case if the member state chooses not to comply with the requests therein, and that we then have to go down the judicial route. And there can be all sorts of specific conditions that the Commission at this stage imposes on a member state to come back into compliance with EU law and to correctly transpose EU legislative acts. Now, let's move to the next stage. So what do you do in the member state when you get one of these reasoned opinions? Well, I've mentioned you've got 2 months to reply, and you have to then report on what measures you are taking in accordance with the reasoned opinion and the steps outlined in the Commission's letter. All right. Now, of course, where it comes to big areas of public policy and law reform, you can't necessarily achieve everything in that 2-month period. So the Commission will be often open for extended dialogue with the member state, as long as it's clear that there are political commitments to move forward with coming back into implementation of EU law. All right. So this is really where it becomes a sort of a negotiation between the Commission and the member state. And in essence, the way the Commission looks at this is whether it is satisfied that the member state really means it when it says it will come back into compliance with EU law. Is this a real commitment, or are they just trying to extend this process or avoid EU law? Okay. So this is the purpose of this process is really to open a dialogue, again, to give the member states some time to more correctly implement the obligations it has under the treaties. Now, the Commission then will be on an ongoing basis assessing what is happening in the member state, not just what the member state says, but it will be looking at the laws that have been adopted or changed in the member state and seeing if those are in compliance with EU law. It'll be looking at policies and budgets and funding. And it really will be on an ongoing basis, assessing whether or not the member state is now correctly transposing or implementing EU law. And in the best case, the Commission and the member state will come to an agreement that compliance has been achieved. And this infringement process that was begun will then be closed, and that will be the best case. The Commission might also decide, however, that some positive steps have happened, but not enough to come into full conformity with EU law. This is a case of partial compliance, and again, will require the member state to continue the efforts of implementation and set deadlines about what it expects to see, and will be monitoring on an ongoing basis. And in the worst case, of course, the Commission might decide that too long has gone or too little has happened as to mean that the member state remains in violation of its obligations under EU law. And in this case, which of course is the outcome that everyone wants to try and avoid, but in this case, the Commission does indeed have the power to refer the case to the Court of Justice for the European Union. Okay. This is the final case if there hasn't been an effective collaboration and if the issues haven't been addressed by the member state in question. And this is where the Commission collects the file, collects all the evidence of what the member state has done, and it really puts the case before the Court of Justice, which has binding legal authority to deliver judgments on whether or not, in its view, EU law has been complied with, and if not, it can impose binding judgments on the EU member state. And this can include all sorts of things, but in particular can mean sanctions are taken against the member state, having an impact both on its membership in the EU institutions, but it also can impose things like financial penalties until the EU member state comes into compliance. So this is a very strong power that can be used at the end of the infringement process. But as you can see, we don't get to this until there has also been extensive effort to try to come to a negotiated outcome and to bring the member state back into compliance with EU law. Now, I'm going to skip ahead. I don't know if we have about 10 more minutes, John, do we?
Yes, we're running tight on time. Yes, I just wanted to draw your attention to that. Thank you.
Yeah, I'm going to zoom ahead. So here, let me give you a bit of a reality check. I want you to know, and even though Validity is very focused on strategic litigation, you need to know that very few cases ever reach the Court of Justice, and even less do cases reach the Court of Justice of the EU in relation to disability rights. It's really uncommon. The whole process or the whole kind of opportunity for us in civil society is about how we collect information to inform the European Commission and to inform the whole transposition process as it is underway. And so there is an ongoing role that we in civil society are uniquely placed to play, and we are often the ones who are the sources of the complaints and the evidence that is needed to justify these more powerful enforcement actions against member states that violate EU law. You need to know, however, that effective and real complaints need to navigate these tricky questions of competence and EU law. And what I would say to disability rights advocates in this field is not to get hooked on these technical questions. That is precisely why organizations like Validity exist, because we do navigate this complex EU law all the time. It's exactly why EDF focuses on EU policy as well. So I would say where there are issues, don't leave it to the activist alone to try and figure out all these complex processes. Bring us in, because we often have the expertise on litigation and EU policy that can be drawn on when pursuing complaints. Okay, so strategic complaints really need to be very well grounded and evidenced. Now, I'm going to give you a short case study because we have worked through these processes in various ways, and we've also used strategic litigation to try to influence the implementation of EU law. And the case study I've chosen here comes from Bulgaria. It relates to ERDF, European Regional Development Funding, in that country, which is targeted specifically for people with disabilities in 2018, 18 million euros. And that funding was provided to Bulgaria and was used in a way to promote the building of care homes and daycare centres. And this is quite a complex area, but we at Validity and our partners in Bulgaria, people with disabilities in Bulgaria, were really concerned that this funding was going to violate EU law, was going to violate the CRPD and right to inclusion. And in fact, we were trying to prompt some action to make greater compliance with the CRPD and the Charter of Fundamental Rights. And so the essence of this problem, and it will be familiar to some of you, is that this funding was provided to Bulgaria in the context of its deinstitutionalization strategy. And in essence, that strategy envisaged moving people with disabilities from big institutions to smaller institutions in the communities. But these are often smaller care homes that actually are not fully included in communities. And in this case, they weren't. They were still quite separate from the community and society in a small municipality. And ultimately, this funding, in the views both of people with disabilities in Bulgaria and their representative organizations, it was just going to change the type of segregation that people with disabilities were facing. They might be in smaller institutions, but people couldn't come and go as they wanted. They couldn't choose whether or not they could live there or elsewhere. And so really it was undermining various rights. And actually, this wasn't just the perception of people in Bulgaria or us as lawyers. This was also something that the CRPD committee said to Bulgaria, that this approach of the country really wasn't acceptable when it came to Article 19 of the CRPD. Why? Well, because ultimately it was not achieving the goal of true independent living and inclusion in the community. And in fact, in Bulgaria, this was the final stage of the DI process. There wasn't then going to be next steps, for example, to support people into their own housing. This really was the end of the process. And so the CRPD committee was quite clear this violated the CRPD. And I should point out that given the CRPD committee have found that this to be a violation of the CRPD, that also means it has an impact on EU law, because EU law needs to comply with the CRPD, as I've mentioned, with the EU being a member of both the CRPD and all of the member states as well. So this is a complex but important legal question, and the question is, how are we going to deal with it? So the first thing that the Centre for Independent Living in Sofia, along with our friends at the European Network on Independent Living and us did, the thing we did first is what we are allowed to do under EU law, and that is to complain to the relevant Bulgarian authorities that these measures are actually violating the rights of people with disabilities, to the right to independent living in particular. All right, and we did that. And unfortunately, not surprisingly, I would say, the Bulgarian authorities just rejected our complaint. They thought this was a positive step forward. They thought building some new group homes was a good thing, and they just dismissed the complaint. And in fact, in dismissing the complaint, they also didn't consult people with disabilities at all on either how they would handle the complaint nor the wider deinstitutionalization policy. So really, they were not very cooperative. They were not really including the voices of people with disabilities in this process. Now, the Centre for Independent Living and we were concerned about that. And we thought that that meant that those people were going to have their rights violated, and really someone needs to step in and remind Bulgaria that it should be using this funding to promote real inclusion, not just smaller institutions. And we complained to the European Commission, asking it to suspend the payments. It has powers to suspend payments in this case, and to order Bulgaria to use money of the EU in a better way. Okay, so to promote Article 19. Now, the European Commission also refused to act, and it gave two key legal reasons. The first is it said it lacked competence to act in this area. Why? Well, because it argued that Bulgaria ultimately is responsible for national social policy, so really they can't do much about that. But secondly, and this is where we had a very big disagreement with the European Commission, they argued that the CRPD doesn't prohibit these types of investments. Now, we disagreed with that view. So what did we do? We then referred this particular call for proposals and this issue to the Court of Justice of the European Union, and specifically the General Court. Now, I won't bore you with the complex legal argumentation in this case, but the long story short is there was some acknowledgement on all sides that this was a problematic investment, okay? And there should have been more involvement of persons with disabilities specifically. But the court declared the case inadmissible. And here's where a real issue exists in EU law and the influence of people with disabilities, is that it said ultimately funding decisions did not provide, were ultimately not subject to challenge by people who are not directly affected. Now, the people who were directly affected by this funding, all of them were people with disabilities detained in big institutions, not connected with their families, and they were under legal guardianship, meaning they couldn't themselves go to courts. The court nevertheless said, we still can't rule on this issue, and therefore the case is inadmissible. They said that we as NGOs can't challenge decisions made by the European Commission unless we are directly affected by them. And the court held that we had no legal standing. So why I share this is that it's obviously not a victory in terms of implementing EU law. But it is important to show that this case also had some other impacts beyond the courtroom. Okay. I'm going to skip past this because I think I've covered it. What it did do is raise awareness within Bulgaria about Article 19 and the CRPD and the rights of people with disabilities who, for much of their lives, had been left in institutions and really weren't given a chance to live in the community. It did actually contribute to a lot of debate as well between civil society and the European Commission about what it means to promote Article 19 of the CRPD with EU funding. And ultimately, we did actually see that progressively there was greater awareness of the need to look at these types of investments much, much more carefully than ever before and ensure that people with disabilities are much more directly involved, both in the monitoring and decision-making process, as well as the ultimate goal of ensuring the inclusion of people with disabilities at the end of the process. So I share this story because here we've used part of the legal framework on the implementation of EU law to try and ensure an improvement in the rights of people with disabilities. And you can see we got a bad judgment, if you like, from the Court of Justice of the EU, but actually it wasn't the end of the story. It really has promoted some more positive change, and which means that DI policies are becoming much more inclusive of organisations of people with disabilities themselves. And the EU understands, I think, why, or the EU European Commission understands why this is so critically important. Otherwise, mistakes are going to continue to happen. Now, I'm going to close with a couple of last slides about from law to action on the role of civil society in this whole transposition and enforcement process. And we've seen, as I've mentioned, that enforcement isn't automatic, but we as NGOs, we as organisations of people with disabilities have such a critical role in triggering real enforcement. Okay, that's because we're the ones who see the gaps. We're collecting the evidence, and we know from the day-to-day lives of the people we support what the reality is. That's because we're in a unique position to advocate, and that's because we can hold systems account by using our democratic rights to speak up and to complain when we see problems. We do that through our activities to monitor. We monitor real life, the laws, the policies, the funding and the services, not just what they say on the papers. We're collecting real testimonies, and we are in a very good position to identify patterns and barriers that people with disabilities are facing. And that is critical information for the entire transposition process. It is critical information for the entire infringement and enforcement process. We are absolutely very well placed to build evidence through doing our own research and through disabled people doing their own research on the impact of EU law. And we are very well positioned to analyse those breaches, not just in terms of EU law, but in terms of the CRPD, which really is our treaty. And we are uniquely placed to create reports and those legal arguments about why EU law and policy must be better aligned with the rights of persons with disabilities. We can drive the process through pursuing strategic complaints. And often I find people are worried about taking complaints because they think it will create a problem in the dialogue with the member state or with the ministry, etc. But I would say there are organisations will have different tolerance levels for this, and it's important we work together. Some, like Validity, might be well positioned to take complaints quite independently, while others are better at maintaining that ongoing partnership around the table. But we can still work together in the background to support each other. Complaints can often open the door for others to intervene and get around the policy-making table. So don't be afraid of complaints. Sometimes they're important. And finally, of course, we can do what we do best, which is to advocate, raise pressure, and raise the awareness of the wider public. Now, I know I have to close, John, but in reality, we do this on an ongoing basis. And I just share this slide. You'll be able to look at it afterwards. But we've used this strategic litigation to have real positive impact on EU law and policy, not just at the Court of Justice, but also the European Court of Human Rights, really to promote greater alignment with core CRPD rights. We've worked, as you heard, I think from Alejandra, about the need to also work with the media and to raise public awareness of this entire process. And for us, it's critical, as I've mentioned, to work in partnership as organisations of people with disabilities who may have different views, we might have different positions, but actually building our collaborations and collectivities is critically important. And so I finish with this slide. What works, what's critical in this whole process is that you do need to know something about EU law, but don't try to be an EU law expert. It is often really complex. Let's work together and share that expertise where we have it. We need to build that evidence of the impact of EU policy and law in real life, on the lives of people with disabilities. And we need to do that together as a persistent, long-term engagement, because many of these shifts don't change things overnight. We have touched on the challenges in this process, and the biggest one, in my view, or one of the biggest one, is the time and resources that many OPDs, we just don't have the time and resources to do extensive monitoring. But let's support ourselves or each other as much as we can, and also remind the European Commission of the need to fund us to do this work so that we can remain genuinely independent. And so I close with that. Rights exist, but implementation is the critical part of the picture. And we, you, civil society, have one of the most critical roles in ensuring that EU law does make a real impact on the lives of people with disabilities. John, I stop there because I know I'm bang out of time. Thank you.
Thank you. Indeed, we're at time, but it's really important. I think for many individuals, not just persons with disabilities, but in general as citizens, we feel somewhat powerless against the machine. And what you've shown is how, with the right approach, it's possible to make things better and different. We are agents of our own situation, that there are channels that we can use. It's not necessarily going to be easy. We may get setbacks along the way, and what we do achieve in the end might not be what we set out to achieve at the beginning. But altogether, things are possible, and indeed working together. And I think really emphasizing the importance of organizations and working in organizations of persons with disabilities to try to pool some resources and capacity to be able to be in these kinds of struggles for the long term, because often that's what it takes. So thank you so much.